of short-sightedness in the interest of power and profit. To turn to another area, in April 2005, Congress enacted the Energy Policy of 2005, which, if implemented, will permit drilling in the Arctic National Wildlife Refuge, thus depleting domestic supplies and increasing long-term dependence on oil imports. Echoing Washington rhetoric that its lobbyists probably wrote in the first place, the industry hailed the congressional decision as a step to create jobs and reduce dependence on foreign oil. In fact, long-term dependence is increased, and jobs is the familiar technical term used to avoid the vulgar seven-letter word profits. Emptying the stores of oil in the Strategic Petroleum Reserve would appear to be a more reasonable way to deplete domestic oil supplies. Unlike ANWR drilling, it would not have harmful effects on the environment and indigenous people. But that would not yield industry profit, and the plan could never be sold to the public in those terms. The bill passed shortly after ExxonMobil released its report, The Outlook for Energy, a 2030 view, forecasting that non-OPEC world oil production would peak by 2010. Previously, the corporation had taken a conservative stance on peak oil speculations. Looking ahead, the report dismissed alternatives, such as Canadian oil sands, as unviable, and could foresee no alternative to vastly increased OPEC production, primarily in the Middle East. If the predictions are accurate, depleting domestic oil supplies entails even greater reliance on Middle East oil than had been anticipated. Hence, further military intervention, instigation of terror, and continued undermining of the initiatives toward democracy and sovereignty that the United States has been blocking for decades, and will have to continue to block in the future. Middle East oil production means primarily Saudi Arabia, and potentially Iraq. The latter a particularly valuable prize, not only because of its enormous resources, but because it is the only remaining place on Earth with huge untapped reserves that are furthermore very cheap to extract, hence promising a bonanza to the energy corporations that will have privileged access, primarily American and British, if the invasion succeeds in imposing Washington's effective rule. The crucial issue throughout the post-World War II period, however, has been control more so than access or profit, and that concern for critical leverage in world affairs will presumably remain true for the foreseeable future. Among the most salient properties of failed states is that they do not protect their citizens from violence, and perhaps even destruction, or that decision-makers regard such concerns as lower in priority than the short-term power and wealth of the state's dominant sectors. Another characteristic of failed states is that they are outlaw states, whose leaderships dismiss international law and treaties with contempt. Such instruments may be binding on others, but not on the outlaw state. We turn in the next chapter to this principle of self-exemption from the laws of war and other international norms. Chapter 2. Outlaw States. In one of his last works, John Rawls, America's leading late 20th century political and moral philosopher, outlined his ideas on a morally acceptable international society. He proposed a law of peoples, which he argued should be appropriate for the society of liberal democratic peoples and the society of decent peoples, the latter not liberal democracies, but with characteristics that render them admissible to a just international community. Outside the realm of these well-ordered peoples, Rawls says, are outlaw states that refuse to comply with the law of peoples. The law of peoples includes the commitments to observe treaties and undertakings, to recognize that all are equal and parties to the agreements that bind them, to reject the use of force for reasons other than self-defense, and to honor human rights, and other principles that should be readily accepted, though not by outlaw states and their acolytes. The idea that all states are equal and parties to the agreements that bind them has long been codified in international norms such as the Geneva Conventions, first enacted in 1864 to protect the wounded in times of war, and since expanded through a number of additional protocols, most notably in 1949 and 1977, and the principles of the Nuremberg Tribunal, established to prosecute Nazi war crimes during World War II, and adopted by the International Law Commission of the United Nations in 1950. Article 3 of the Nuremberg Principles states clearly, "The fact that a person who committed an act which constitutes a crime under international law acted as head of state or responsible government official does not relieve him from responsibility under international law." So, for example, the German foreign minister was hanged for such crimes as his role in the preemptive attack on Norway. Furthermore, grave breaches of the Geneva Conventions are universal and extraditable offenses within the jurisdiction of any party to the conventions, and these states are obliged to enact any legislation necessary to provide effective penal sanctions for persons committing or ordering to be committed any such breaches. The threat of adherence to the rule of law is serious indeed, or it would be if anyone dared to defy the single ruthless superpower whose leadership intends to shape the world according to its own forceful world view. Torture scandals. In 2002, White House counsel Alberto Gonzales passed on to Bush a memorandum on torture by the Justice Department's Office of Legal Counsel. As noted by constitutional scholar Sanford Levinson, according to the OLC, acts must be of an extreme nature to rise to the level of torture. Physical pain amounting to torture must be equivalent in intensity to the pain accompanying serious physical injury, such as organ failure, impairment of bodily function, or even death. Levinson goes on to say that in the view of J. Bybee, then head of the OLC, the infliction of anything less intense than such extreme pain would not, technically speaking, be torture at all. It would merely be inhuman and degrading treatment, a subject of little apparent concern to the Bush administration's lawyers. Gonzales further advised President Bush to effectively rescind the Geneva Conventions, which, despite being the supreme law of the land and the foundation of contemporary international law, contain provisions Gonzales determined to be quaint and obsolete. Rescinding the conventions, he informed Bush, substantially reduces the threat of domestic criminal prosecution under the War Crimes Act. Passed in 1996, the Act carries severe penalties for grave breaches of the conventions, the death penalty, if death results to the victim of the breach. Gonzales was later appointed to be Attorney General, and would probably have been a Supreme Court nominee if Bush's constituency did not regard him as too liberal. The Justice Department rulings met with widespread condemnation. Sanford Levinson charged President Bush's legal advisers with the articulation, on behalf of the Bush administration, of a view of presidential authority that is all too close to the power that Carl Schmitt was willing to accord his own Führer, referring to the leading German philosopher of law during the Nazi period, and the true éminence grise of the Bush administration. Or perhaps the true éminence grise is Robespierre, who instructed the French Convention that the Jacobins should subdue liberty's enemies by terror. As Levinson points out, however, there was some basis for the rulings. The U.S. Senate, when ratifying in 1994 the UN Convention against torture and other cruel, inhuman, or degrading treatment or punishment, provided what Levinson calls a more interrogator-friendly definition of torture than that adopted by the UN negotiators. This definition has been used by the President's legal advisers to justify the torture of detainees in Guantanamo, Iraq, and Afghanistan, and